My name is Juliet Boyd, and today we are going to be talking about how to advise your client who is stopped under suspicion of driving under the influence. As a lawyer who practices criminal and traffic law, I get this question a lot, and the answer lies in the Constitution as it is recited on television every day. You have the right to remain silent. Everything you say can and will be used against you in a court of law, and you have the right to an attorney. It is important to understand a little bit about the background of driving under the influence investigations in order to assist you in advising your client. You should know that police officers are trained to catalog every observation of your client. The police officer has watched your client's driving, and it is likely being recorded by a video camera. He watched when your client moved over the center line. He watched your client's reaction when he turned on his Mars lights. He watched that when your client pulled over to the curb, he struck the curb with his tire. He will note that when he walks up to the window and your client rolls down the window, that your client has red, bloodshot eyes, an odor of alcohol, and slurred speech. So as you can see, it is important for your client to say and do as little as possible. My first tip is that your client should be polite and respectful to the police officer. The officer is only doing his job. If your client is rude and obnoxious, this will be used as evidence of his intoxication. Your client should say as little as possible to the police officer. He must provide the police officer with his name, address, and driver's license information, but this can be achieved by handing the officer their license. You can advise your client to tell the police that, on the advice of counsel, they're going to assert their right to remain silent. This is a tip that's a little harder for some clients to follow. Some people are raised to cooperate with authority figures, and some people, quite frankly, think that they can talk their way out of a DUI. It is much better to assert the right to silence. Your client has the right to refuse field sobriety testing. At some point, the officer will ask your client to exit the vehicle and to perform some roadside tests. Typically, this is the horizontal gaze nystagmus test, the walk and turn test, and the one-legged stand test. The purpose of these tests is to provide the police officer with an opportunity to observe your client's ability to follow instructions, to balance, and his physical coordination. It is likely that these tests will be recorded on a video camera as well. What you should know is that these tests are negatively graded. They are almost impossible to pass. In addition, your client is very nervous during this interaction, and they have not had an opportunity to practice these tests. They are also on a roadside with cars whizzing by and the Mars lights flashing in their eyes. So these are not the optimal conditions for performing a test. It is more advisable to refuse to perform the field sobriety tests. Your client should not lie to the police. At some point, the police officer will ask them how many drinks they've had that evening. It is preferable to assert the right to silence than to tell the police officer that they've had 4 or 5 beers, which is not going to be helpful to their case. Your client may refuse the PBT or portable breath test. This test is typically offered at the roadside. The purpose of the PBT is to show the absence or presence of alcohol and to support the police officer's determination of probable cause to arrest your client. If your client has consumed any alcohol, they may and should refuse to perform this test. Your client has the right to refuse the breathalyzer test. This is the evidentiary test that they will be offered at the police station. The purpose of this test is to accumulate scientific evidence to use against your client. If your client has had any alcohol to drink, they should refuse to take this test. Many clients report that they felt fine, so they submitted to the test, and then the results come back much higher than they had anticipated. This is because many clients have a tolerance to alcohol. Clients will be told at the time that they perform this test that if this is a first offense, that they will be suspended for 12 months if they refuse to take the test. However, their driver's license will be suspended for 6 months if they take and fail the test. It is better to assert their right against self-incrimination than to take this test. If your client feels that they are being badgered, they should assert their right to a lawyer. This should cause all questioning and interrogations to immediately cease. It is important to hire a lawyer who is experienced in this area of practice. DUI law includes civil and criminal law, as well as scientific tests and evidence. It is important to hire a lawyer who's experienced in this area. I hope that these tips were helpful. To learn more about the benefits of joining our ISBA Traffic Laws and Courts Section Council, check the ISBA website. This is also a helpful resource in finding lawyers that are experienced in the area of DUI law.